a certification for attorney fees. That was the day that Ms. Kaspersky brought the party's college daughter to the courtroom. I did so and I submitted it on August 17th. Ms. Kaspersky was given 5 days to respond, which would have been August 22nd. She did not respond. It's now 3 weeks from the date that she was to respond. So I just want to remind the court I haven't received an order or any decision on that. Second, I just wanted to report to the court that unfortunately, and I have a printout, today is September 12th, and I have a printout from Carnegie Mellon. I have one for everybody, so if I can just show the court.
All right, so you want this marked?
Yes, Judge.
What would you like to mark?
No, wait, I object. This is part of my trial. You guys are hastily putting through stuff before you have all the information. You ordered her to take out loans, and she's not a part of this litigation. You have precluded her from here. You've kicked her out of court, and therefore right now we need to go on with the trial, and that will be a part of my exhibit.
Okay, so noted. Overruled. You may continue.
So I've just handed the defendant...
What do you want to mark it?
Well, Judge, we were marking things P, Roman numeral I, or 1, and then 2 when we were dealing with this issue, so I suggest we mark it P, Roman numeral 3.
That's very confusing to me.
I'm just trying to keep it because that's what we did when we were
What's
here.
your next exhibit? Or your last exhibit? And then I'll hear all your objections substantively, but procedurally I have no problem marking this. That's a comment was addressed to Ms. Kaspersky.
Mark it P210.
Okay, P210 for identification. Okay, what is this?
This is a printout from Carnegie Mellon's student portal. And if the court will recall, when we were here with this issue, Mr. Kaspersky testified that he did not have access to the financial aid portal as of August 3rd.
I object. That's hearsay because...
Ms. Kaspersky, you'll have a chance to respond, but please, let's be courteous and dignified. Let her make her argument. There's no jury here. When she's finished making her argument, I'll be more than patient, as I always am, I believe, to hear anything you have to say in response. I understand that you're having difficulty with this, but I don't know what we're talking about yet. So after Ms. Kaspersky finishes, after counsel finishes, before I make any decision. Okay, you may continue.
After court on August 5, he was denied all access to the portal. Today's September 12, and as of 6:29 this morning, a.m., Mr. Kaspersky made another printout to demonstrate he still denied that access. In the emails, and those are all attached to my papers that I submitted to the court on August 17, how much she has paid toward the tuition, and the court ordered that the party's daughter would apply for loans. But in the event either party wanted to use a non-marital asset to pay, that parent could certainly do that. So Ms. Kaspersky testified that she paid $4,000. I've asked her for documentation. I still have not received that. And because Mr. Kaspersky cannot get into the portal, we don't know. Ms. Kaspersky, in her email to me, said that Ariana was instructed to terminate the access. I asked for that person at Carnegie Mellon's name and all contact information so I could confirm that. She also refuses to give that to me. So as of now, we know that Ms. Kaspersky called the court on August 23rd, advising the court that she suffered from COVID and she was symptomatic, and therefore court on the 25th and 26th of August had to be terminated. Yet on August 27th, she drove Ariana to college. I find that curious. And unfortunately, according to the consent order fixing custody and parenting time, Mr. Kaspersky was and is to see his children on his birthday. Obviously, Ariana is at Carnegie Mellon, but they have their son at home, and I have to report to the court that he was told that his son would not see him on his birthday. This is now the third year for Mr. Kaspersky being deprived of spending his birthday. And I have an email from... I'm sorry?
This is from a year ago.
Oh, okay. Well, I have Mr. Kaspersky's email exchange with his son, and his son told him that he was at a cross-country meet, and Mr. Kaspersky is able to identify on his phone where the son's phone is located, and he was home. So it's unfortunate that, again, we feel as though another order, and I don't think it's a coincidence that this is happening. And I do believe, I'm bringing this to the court's attention because I find it to be a violation of the August 10th order, that the parties are not to discuss what's going on in this courtroom at all with the children. And I'm just terribly disappointed in what's going on and how the children are being affected. Thank you, Judge.
Okay,
First of all, that is all hearsay from their point of view, which is not true. He has testified from January to July without any, evidence, without any statements. It's proven that he took marital money. It's proven that he gave me $540 when he left the house, and that's caring for the kids. And I paid all of her tuition. And you hastily put through an order without her presence. You kicked her out of court, which you're not supposed to do. And they supposedly care about him. My kids are not here to speak for themselves. He should not use the kids as any reason. He has not seen them for the 2-3 weeks that's based on the consent order that he wanted for this summer. He did not see them last summer.
Let me ask you some questions. Let's stay focused here. Number one, I did require that you provide documentation to Ms. Cipriano regarding how much you paid Carnegie Mellon. Did you provide that?
I can give that to the court right now.
Let's have it. And this is for the fall semester that we're talking about that we're currently in, correct?
Yes.
Let me see what you have. I'll mark that as your next deed exhibit. Do you have any idea what your last deed exhibit was, Ms. Kaspersky?
I'm sorry?
Do you know what your last defending exhibit was?
Yes.
What is it? In your proposed exhibit?
Well, can I just...
We're going to mark this.
Okay.
I just don't know what... I'm trying to get a number to mark it.
Okay, let me just put this together. Let's just do 150.
150. Okay, D 150. Let me see what 150 is.
Can you give one to the court? Thank you.
All right, thank you, officer. D 150 for verification. 20 pages. Tell me what D 150 is.
Oh, wait. Let me just take a look. I'm so upset. I'm shaking. So we have to apologize.
Take your time. You want my copy back?
Yeah, let me just make sure.
Okay, you want my copy back. Take your time, please. Here's the officer. All right. Tell me what 150 is, please.
Give me a minute.
Would you like a glass of water, Mrs. Kaspersky?
No, I just need to get situated. I have no internet access.
Tell me what D-150 is.
Okay, so D-150 is it says it's dated August 2022 invoice for Ariana Janina Kaspersky. There's an invoice number 495502.
What this is proof that Carnegie Mellon has been paid.
Correct.
And your testimony is you paid it.
Correct.
Okay. So, Ms. Kaspersky, this satisfies your request?
Cipriano.
I apologize. I don't know why I'm doing that. Please forgive me.
This is what we wanted to know.
Okay,
She
so-
paid it, I would like confirmation that it was paid by a non-marital asset, because that was the instruction.
Much money, and he didn't pay a part of it.
Well, we're going to get through all that at trial. That's the purpose of trial. I'm working as quickly as I can to get through all this. And you may be right. I haven't heard the whole case yet. What we're dealing with was the college education issue. But I don't, I'm not at a point to argue the final merits because I haven't heard the whole case yet. I will make a final determination after all the evidence is in.
Which is why it was a hasty order that was placed in before. He should have at least paid 51%.
Well,
And he owes me that right now.
As I said, you were able to pay it without prejudice. What that means is if I find you're correct, you'll be reimbursed. I said that all along. The reason it was hastily decided was because I was told the deadline, pardon me if I look at the allergy, that the deadline wasn't pending, she would be able to attend.
No,
That's why you can disagree with me. That's why I did what I did.
Judge,
If I made a mistake, that's what the appellate
Judge,
is for.
that is what you heard from one side, and this whole trial has been very one-sided,
I know.
where you've only listened to one side.
I'm not going to respond to that. I know you have indicated that you're not receiving a fair trial. I maintain that you're certainly right to have the right to maintain that. But I differ, and I think I've heard from everybody. I may not agree with somebody, but I gave everybody plenty of opportunity to tell me everything they want to say. I don't think anybody in fairness can say they weren't heard. They may not have been agreed with, but they were heard. There's a difference between hearing someone and agreeing with someone. But there is no doubt in my mind, I heard from everyone extensively on this issue.
Okay, so if you heard from everyone, number one, you did not hear from Ariana. You precluded her from it, and you kicked her out of court.
I'm
Okay,
moving on.
and according to Ritchie versus Ritchie, which is the main, case law that says New Jersey parents are to contribute to their child's education, and that involved two parents who did not want to contribute to their kid's college. The child got her own attorney and sued both of the parents. The parents were obligated to pay, the girl won. The parents were obligated to pay her tuition and pay her attorney fees. And that's what you should have done, was given her an opportunity to say, you know what, I'm not going to listen to anything the defendant says. You should have your daughter get her counsel, and she can, be a third party. And that's what should have happened instead of an order rushing through. If it was so urgent that he did not have to pay and he can get out of paying, then, you should know that should have came from me or my daughter and not somebody who doesn't pay.
I disagree with your characterization of a prior court order. If you think it's wrong, you can certainly appeal. I understood what you said. I understood that it was a commitment by both parents to educate their children. There was no dispute on that. The question was how to put a Band-Aid on the problem until I can get through the trial. And I came up with what I thought was reasonable in my discretion after listening to everybody. It's not what you wanted. I understand that, and I said it without prejudice, and this case isn't over yet. But now that Ms. Kaspersky has the information, the second issue you raised, Ms. Cipriano, the second issue you raised was his access to the court. Do you contend that Ms. Kaspersky has anything to do with his denial of access to the court?
Yes.
And what's the basis of contending that she has done this?
The fact that she brought her daughter to the courthouse, Judge, and the fact that her email sent on August 8th at 11:08 a.m., which is attached to my certification as Exhibit G, which has previously also been marked as P Roman numeral 2, she said, and I quote, "I am not doing things behind my daughter's back because he refuses to pay," end quote. I believe indicates that she is involved with this child. I think that she will continue to involve the child. I don't find it to be a coincidence that after we left court on August 5, that's when Mr. Kaspersky's access to the entire portal was then terminated. It is contained in the court's order specifically that he is to be reinstated, his access. And it further states that if the child does not give him access to the portal, that the court can then take that into consideration when assessing whether or not either parent will have any financial obligation to assist in her college expenses. It's now September 12th. It's been well over a month. She has not. We have come to court since August 10th when we were adjourned for the day. We were just here last week. We appeared via Zoom, but we were with the court nonetheless. I think that Ms. Kaspersky's directing Ariana, and I think that she's telling her that your father...
Objection, that's hearsay.
And the reason why I think that is because in her own words, she says that...
Judge, you've been holding this trial with opposing counsel all based on hearsay. They are using the kids when they have precluded the kids as a witness.
Argument. This is trying to get to the bottom of why Mr. Kaspersky has been denied access to the portal despite my court order.
Did you ask me?
I'm not. Well, I will once Ms. Cipriano's finished. I could see she stopped to look for a document and you jumped in.
On Friday, August 5 at 6:21 p.m. So that is the day that we were in court. Ms. Kaspersky writes to your former law clerk, Tamara, "I am copied and Mr. Kaspersky is copied." And she writes, quote, and this is attached to my certification as Exhibit E, and it has...
Certification date?
August 17, and it has previously been marked by the court as P Roman numeral 1. And she writes, quote, "Ariana had called the school as she is the main person that the bill goes to. The advisor had told Ariana to remove Mr. Kaspersky from their invoices completely. This is Carnegie Mellon's rule. Since he is not contributing currently, the advisor needs to show the school he will not contribute this year. Only parents that contribute has access to the system. Her advisor will talk to the committee to see what they can do to help Ariana since one parent is unwilling to contribute. I don't make the rules. I am doing what someone who is helping her is saying. If he needs to have access, the court needs an order that specifies that he is not contributing to her college this year, but the court is ordering Carnegie Mellon to give him access despite it. If he is co-signing on a loan, he is not contributing." End quote. She says in her email that Ariana called the school. She then describes in the email the conversation that Ariana had with the school, including that Mr. Kaspersky is allegedly unwilling to contribute. She says, "I don't make the rules. I am doing what someone who is helping her is saying," which just logic tells us. That means that if Ariana was the one on the phone, in order for the defendant to get the information, Ariana would have had to have a conversation or communicated in some way with her in order for Ms. Kaspersky to author the August 5, 2022 email sent at 6:21 p.m.
Okay, anything else you want to bring to my attention?
He should have access to the portal, Judge. Of course he should. It's his daughter. He loves her. He cares about her. She's following in his footsteps to become an engineer, which Mr. Kaspersky also is. He can help her. He wants to help her.
So pay her bill. Pay her bill.
He drove her items, her personal belongings, to the college in a car by himself with all of her items, while Ms. Kaspersky, who allegedly was suffering and symptomatic from COVID, couldn't come to court but could drive her daughter to college, had the child in the car with her. Thank you.
So, I will ask you now, did you,
Thank you.
So, I will ask you now, did you, I guess in the first instance, speak to your daughter about the particulars here, and the second instance, have anything to do with the school removing Mr. Kaspersky from the portal?
Number one, the bill is in her name. She is 19 years old, right? It's not like I'm the one that logs in as her. She logs in as her. Number two, she sees who pays because she sees it's her account. She is an adult. She's 19 years old. So the court needs to remember that. You're acting like she's 5 years old. Okay? Secondly, okay, she is not following in his footsteps. She, through many years, decided on her own what she was going to do. And if I got a proper trial, and the court did not rationally listen to just one side and rush through whatever they wanted. Secondly, she asked CMU for help with her tuition. And she had to explain why. Because in order to get the tuition, number one, every college is need blind, which means if the people know I am unemployed, which means, you know what, it was just me and my tax statement and my pay stub, her tuition would be zero, okay? If he was not a part of the picture, if he was not even alive, I would pay $0 for her tuition. It's based on income. He has gotten into the FAFSA. He had uploaded his tax forms, and it's because of his $200,000 income that we have to pay the full tuition. They are a need-blind university. Most competitive universities do not give out huge scholarships because everybody is smart. It's hard enough for them to get in, number one. Number two, the woman needs to prove to a committee, and she has to plead our case to other people, that only one parent is paying and that the other one is not. So she has to explain to them. And what she said to Ariana is the court needs to send us an order. So you decided hastily just to put an order in because they want you to, so he can get out of paying. He loves her so much. Reimburse me the money right now because I am suffering. Give me back the $23.5 that he took. Give me the child support that he owes me, okay? Number two, you did not hear from her. This court is using it like you guys are shielding her from anything, but in fact, you're causing her more harm. He's causing more harm. She is 19. She deserves to have, she deserves to be spoken to by this court. And if for everything that you said during this trial that you believe nothing that I say, there's nothing that I can show you that's ever evidence, then you should have said, let Ariana hire an attorney and the parents split for the attorney. She was never given a chance to speak. They should not use her, and they should not be able to speak for her.
Okay, now to answer my questions. Again, did you have conversations with Ariana about the financial situation, number one? And number two, did you have anything to do with Carnegie Mellon removing Mr. Kaspersky from the portal?
Number one, college is a entire family discussion. So it's an entire family financial discussion. Okay, but college is an entire family discussion.
Is it a yes or no in this particular case?
According to the Newberg criteria, it is an entire family
Ms. Kaspersky,
conversation.
the next words out of your mouth, please, should be yes or no, or you can't answer. 2 questions. Yes, no, or you can't answer. Did you have conversations with your daughter about your financial circumstances of paying for her tuition? Yes, no, you can't answer. Secondly, did you have anything to do with Mr. Kaspersky being denied access to the portal?
You
Yes, no, or you can't
you
answer.
did not listen to anything I just said.
You're not answering my questions. It's a yes or no. What is the difficulty?
So he's not having conversations with her. So how is he expecting her to pay? How is he expecting her to
So
pay?
I don't put words in your mouth. Is it a yes or no?
How is he expecting her to pay? Nobody's supposed to have any discussions with her. We're supposed to hear. So he's not having conversations with her. So how is he expecting her to pay? How is he expecting her to
So I
pay?
don't put words in your mouth. Is it a yes or no?
How is he expecting her to pay? Nobody's supposed to have any discussions with her. We're supposed to hear. Sign this, and in 10 years you will have all this loans that you had no idea you had.
My questions. You're insistent on telling me what you want to know. I'm asking you what I want to know. It's yes or no. It sounds to me like it's yes, but I don't want to put words in your mouth.
I want you to go through the Newberg criteria.
Ms. Kaspersky, I am going to direct you to answer my question. And you can answer, it's an acceptable answer is that you can't answer. But then tell me that. It's yes, no, or I can't answer. I don't understand the difficulty.
I can't answer based on the Newberg criteria.
All right, second question. Did you have anything to do with Mr. Kaspersky being removed from the portal at Carnegie Mellon University? Again, yes, no, or you can't answer.
I've already answered.
What was it? Was it yes, no, or you can't answer?
The committee is trying to help her lower her tuition.
I don't know what that means. Does that mean a yes, no, or you can't answer?
Well, if you have the child here, she can
I'm
explain to
asking
you.
you if you had any involvement, not if the child or anybody else, did you...
Wait a minute, he's not paying here. He's the one that's not paying for his kids, and he's getting away with it.
Did you have any involvement in him being removed from the portal in violation of my court order?
Did he pay towards her tuition?
All right. I'm done. I'm taking a break.
Judges, it's a